realtor with Coldwell Banker, and today I have with me Elizabeth Anderson, who is an estate planning attorney, and she is my go-to person for all questions related to estates, and she's currently working with my husband and I on our estate plan, so I thought she would be a perfect guest today. Thanks for joining me, Elizabeth.
Of course, it's good to see you, LaDawn.
Good to see you. So let's start with the big question. Why is it important to have an estate plan?
I think the term estate plan kind of freaks people out because I think, when we hear the term estate, I think people have these ideas of sprawling mansions, mega yachts and things. But really what an estate is just the things that you personally own. It could be simple. It could be your home. It could be a bank account, maybe some retirement accounts. But why an estate plan is so important? It's because those legal documents allow us to retitle those assets to the appropriate people. It could be your kids, it could be siblings, or even friends. But one thing that we always forget about in estate planning, we really get hung up on the inheritance side of things. There's a lot of documents in an estate plan that actually protect you during your lifetime. So even simple decisions, or we assume are simple decisions like medical decisions and financial decisions, legally cannot be done by anybody outside of yourself unless you have those estate planning documents in place. So that's why it's so important, because we really want to avoid court intervention. We want to avoid the courts during your lifetime, but especially after you've passed.
That makes total sense. So getting into a piece of estate planning, which is the will, why is it important to have a will?
So a will is a great tool because it just helps us identify the people that we trust to settle your estate. The one thing though with a will we've got to be kind of mindful of, at least here in the state of Colorado, a will does not avoid probate. So really the will is just nominating the person who's going to be your personal representative. It used to be called the executor, but they're the same thing. It's just the person we trust to settle the estate, and that gives the person the authority to hand out the assets or to open up a probate if it's required. And that's why we've got to be really careful. If you have a will, just make sure you've got the correct, I call them retitling documents. Make sure that you have beneficiaries on all of your assets. Did you set up beneficiaries on your bank account? On your life insurance, retirement accounts, on your real estate? Did you do that? And if you didn't, there's a probate red flag. So just make sure you're kind of mindful. If you already have a will in place, make sure it's going to do what we want it to do, to give that personal representative the power to actually hand out the assets that you've already dictated in those retitling documents or those beneficiary forms.
Okay. So one of the things that was recommended for us was a trust. Can you tell us a little bit about a trust and why that may be a tool that someone wants to look into?
Yeah, and the reason why, trusts, I think they're really misunderstood, because I think people just assume, trust fund babies. It's
right,
not
that's
just
what I
for
thought.
the wealthy. I know, and really the reason why trusts are becoming kind of a hot topic, and there's dozens and dozens of different types of trusts. So just because we're talking about one trust doesn't necessarily mean all trusts are created equally. But here in Colorado, if you want to be really snoopy, go on to your county assessor's report, type in your address, type in your neighbor's address, and you're going to be surprised. A lot of people are holding real estate in a trust, and most of those are revocable trusts. It allows you to still be in control. You're the owner during your lifetime. It's incredibly user-friendly, but it's a great tool in retitling those assets. In that will, like I had mentioned, we have to put a retitling mechanism in. And sometimes that doesn't work very well. Sometimes we have maybe a blended family, or we have minor children, and we can't easily put a beneficiary on our accounts. And that's why trusts are becoming so popular, is because a trust is just like a bucket. It holds all the assets when you pass away. And then that document actually is powerful enough to retitle those assets. So it's a great probate avoidance tool, but we see it a lot of times when we want to be a little bit more protective over the inheritance, or we have multiple pieces of real estate. If we have real estate outside of Colorado, it can be helpful. It's incredibly helpful if we have a business owner or you own rental units. So I think that's, depending on your fact pattern and your personal needs and your wishes when it comes to a beneficiary, that's sometimes when we'll start exploring, is a trust a better fit at probate avoidance?
Fantastic. So of course, I always want to put the real estate spin on things. So let's talk about the process for selling a house when someone passes away.
Yes. So if we were good, if we were proactive and we put retitling mechanisms on the real estate, then it's going to be super simple. You could have a trust, and the home is actually owned in the name of the trust. And your trustee, that successor who takes over that trust after you pass away, would have the full authority to sell the home in the name of the trust and then get the money out to those designated beneficiaries. There's another type of tool, though, for our clients that have wills and they don't need a trust. We want to make sure that they have what's called a beneficiary deed on that home. It's that retitling mechanism. We just put a beneficiary on the house and we list whomever they want. So let's say we list your two kids on there. Well, all they have to do is then provide a death certificate to the county, kind of like an affidavit saying that, yes, we attest that you have passed, and then now they become the owners. When you inherit through a beneficiary deed or through a trust, it's an awesome tool because the kids actually get a step up in basis. So because real estate has become so crazy of a market right now, a lot of people are going to are having capital gains tax when they sell the house. But the kids won't have that problem because they have inherited the house. They get to, they get to reset that basis. So that can be helpful. When we don't have those tools, though, and we have a home that has to be retitled and we don't have any of those mechanisms, then we will have to open up a probate. And real estate is really, I would say, probably the main reason people have probate proceedings. When you have probate, it can take a while. The earliest legally we can close a probate is in 6 months, but I would say it's typically taking a year or more. And that personal representative is appointed by the court, and then they have the authority to sell it, but they have to sell it in a little bit different of a way. They have to do a personal representative's deed. And most of the time, the realtor or the title insurance company will want you to be represented by an attorney. So there's additional costs when we don't put in those little proactive measures because the probate, when we have real estate, typically it's a longer drawn out process and there are going to be more costs associated with that.
So when a home is in a trust, it can be listed almost right away.
Yeah. Super simple. Yeah, that's the cool thing about a trust. You can put it on the market as soon as you have a death certificate, 10, 15 days later, you could sell that home.
But the other way, if you do not have the mechanisms in place, it could be 6 months, it sounds like, before they can even list the home.
Yeah, I would say at least, and even you could potentially list it earlier, but the problem is you can't touch the sales proceeds until you're closer to that 6 month mark. So that's where it's kind of hard for these beneficiaries, especially if they've had personal costs in, paying for funerals or cremations. And that's where a lot of people are hoping to get paid back from the sale of the house, but it may not be an immediate reimbursement. There may be the court's timeline that we have to work through. And so sometimes it's not as instantaneous to the access to that cash.
Okay. I know a lot of people then would have to maintain the home. So they have to mow the lawn, they have to shovel the snow, which is a lot to put on the beneficiaries. So So just putting these little things in place can make things so much easier.
So much easier. And exactly. And you then have clear rules. We know who's responsible for these things, and we know that they have the authority to delegate some of that authority or to hire help. And so just to make things cleaner, just understanding the intention behind it, what those wishes are, it just helps relieve a lot of that stress. This is an emotional time in everybody's life anyway, let alone trying to figure out the ins and outs and what am I allowed to do and what I'm not allowed to do. Mm-hmm. When you have that proactive approach, when you do your estate plan, all those what ifs are handled. So it's a lot easier for the family to just settle the estate and do what's necessary to get the assets to those beneficiaries.
Mm-hmm. So one of the things that we're trained in real estate is when someone calls us and they have a house to sell and someone has passed away, is we need to ask them if they have received their letters yet. Do you have the letters? Could you explain what the letters are? So when someone is asked that, they know exactly what is meant by that?
Yeah, I love how they call them letters because it's just one piece of paper. Mm-hmm. But the letters are either letters of testamentary if you didn't have a will, or letters of administration if you did have a will but still need a probate. And that's the court order. So in a probate, the judge, once they appoint that personal representative, will issue an order, but they'll issue the letters as well. And the letters is just this one piece of paper that gives them the legal authority to collect the assets, to sell assets, and then make the division to those beneficiaries. But letters are only required in a probate. If you have a trust or you have one of these beneficiary deeds on your real estate, no letters would be required to sell that home.
Fantastic. This has been so helpful, Elizabeth. Is there anything else that you'd like to add that you think might be helpful for people?
Well, I think it's weird to think about this, but as soon as you're 18, you legally need some of these documents. Do you need a trust? Do you need a will? Maybe not. I really do think the full estate plan really only becomes a major issue when you own real estate. Mm-hmm. But if you have adult children, maybe they're going off to college, make sure they have those powers of attorney. A medical and financial power of attorney can be so helpful. So don't forget the little things. I know we always think about what happens when we pass, but don't forget about those tools that are going to help you during your lifetime, or at least help some of those adult children during their lifetime mm-hmm. as well.
Great. Well, this has been so helpful, Elizabeth. Thank you so much. If any of you want to reach Elizabeth, just give me a call. I'd be happy to connect you. My number is 303-710-5817. As always, I would love to help you with your real estate needs, and I'm never too busy for your referrals. Thanks so much.